Hello and welcome everyone. Today we have with us Advocate Asad Alvi sir. He is advocate in Supreme Court of India. In his years of practice, Advocate Asad Alvi sir has not only become a regular face in Supreme Court of India and High Court of Delhi, but also in several tribunals. He is a columnist and writes several articles on legal issues like Enthusia, Vexatious Litigation, Humour and Defamation, etc. Which was published in different leading newspapers like Indian Express, Top Story, Loves, and sir is also permanent columnist of Urdu newspaper Inquilab. He has also translated P.Chidambram several articles in Urdu, which were published in Urdu newspaper. He has also participated in several legal discussion on electronic media and All India Radio. With that, sir, I am Robert Sharma, pursuing my BLLB from UPS Dehradun, and I welcome you to this interview organized by DS on Divah Sprik, which is situated in Delhi. With that warm regards, sir, can we proceed towards the questions for today?
Thank you, Weber. Please proceed.
Sir, so first question is that was the law field was always desired by you, and how was your career as a lawyer?
Yes, basically, I never thought about any other profession. It's the profession of my choice. Yes. The beginning of this profession is very, very tough. Not for me, but for everyone. When you have little knowledge of law, little experience, and little reward of your work, it is very frustrating. You are working hard, but you are getting very small amount of money. But it is a part of this profession. There is an Urdu couplet for this situation. कि ये इश्क नहीं आसान, हमने तो ये जाना है, एक आग का दरिया है और डूब के जाना. It is very tough.
Sir, so proceeding towards the next question, how would you describe your experience in litigation so far, and who were your mentors, like professional who mentored you from starting of your journey till now?
My first senior was Mr. B.R. Narang. He was expert of CPC, expert of banking laws. Then Mr. Manik Tala. He was very young lawyer, not very senior. And one of my friend, Mr. Pawan Saxena, he was senior to me, but not very senior. He was my friend, philosopher, and guide. He supported me a lot during beginning days. Whenever I come across a practical problem of this profession, he was my mentor and he supported me a lot.
Sir, then during your law school, had you always been drawn towards the practice, or were there other dimensions that interest you as well? What do you do?
I never thought about any other profession. It's a noble profession and it is a profession of my choice.
Sir, so this question is out of league. So, do you appreciate the lawyers or judges who quote the jokes of Shakespeare in the courtroom, or something like that?
Yes, because I have also answered you in a Urdu couplet, so I always appreciate it. Writing of judgment is just like writing an article. And every good article needs a good humorous anecdotes, literary references, citing poetry. So if an advocate is quoting jokes and Shakespeare and poetry, it means he's supplying good material for a good judgment, as I think.
Sir, so what is your take on
I wrote an article on this issue, literary references in legal judgment. I found numerous of literary references in legal judgments. So we don't have, we have paucity of time here. Otherwise, I would have cited you so many judgments and so many literary references.
Sir, it's recently I was also going through a judgment by Delhi High Court for that Noida Power City for the operational creditor and the other creditor. So in that judgment also I was reading many of the quoted lines from the authors. So it is beauty of judicial. Sir, what is your
Yes.
take on the defamation as damaging the spine of politics?
Defection, yes. Only spineless politicians cross the floor. They are turncoats. Any politician may leave the party if he is not happy with the policies of the party. But ethically, he should resign first from the membership of the parliament, from the membership of the legislation, because he has been elected on the ticket of that party. It is unethical. You are member of parliament and you are leaving the party. First, you resign from the membership of the MP-ship and MLA-ship, then you join another party, as I think in this regard.
Yes, so I also think that when a person votes, he's not voting for a person but for an ideology. And
yes,
if that ideology break out, that is a major breakthrough.
Of course, of course.
Sir, so your brother, Mr. Asad Alvi, is a former member of parliament and the national spokesperson of Congress as well. So, is there any chance that we see you in politics after being a lawyer?
No, there is no chance at all. Though one political party offered me a parliament ticket in 2019, but I politely declined it. It is not so that I am against the politician or I am against the politics, but I am not a fit person to be a politician.
Sir, what would you suggest to our new graduates looking to practice in the Supreme Court?
Pardon?
Sir, what would you suggest to our new graduates who are looking to practice in the Supreme
For new advocates, Supreme Court is not advisable. I only suggest to read leading cases, pleadings of Supreme Court. These days it is available on internet, and try to listen seniors' argument during regular court hearings. But I don't suggest for a new lawyer to practice in Supreme Court. A new lawyer should start his practice from lower for 2-3 years.
Sir, like talking about the practice, do you find any difference in pre-pandemics and post-pandemics time, like how things have changed?
The first difference is the virtual courts. The virtual courts, and after pandemic, the physical court. This is the only difference, as I have seen during this pandemic and post-pandemic. But I feel that virtual courts are more convenient for lawyers, and especially for new lawyers and for litigants also. And physical courts is slightly difficult for transportation and congestion of traffic, etc. But what would I say? The physical court is an intoxication for the lawyers and judges. They feel more intoxicated, I would say, if they argue in a physical court rather than in a virtual court. Virtual court is just like I'm talking to you, and judges also talking to you. So that feeling you have, it is the only difference between virtual court and physical.
Sir, so former Chief Justice of India, Justice N.M. Ramanna, had developed a standard working mechanism And recently, appointment of Justice UU Lilith as 49th Chief Justice of India has come up with some remarkable changes in working of the apex court. What changes should be made, or you would recommend for betterment of our Supreme Court?
Whether lots of changes are required. First thing, swift listing of cases. If you are filing a case, it should be listed next day, not after 15 days or after 1 month. And lengthy and useless pleadings ought to be abolished from the court filing. Affidavits, wakalatnama, listing performa, it all should be abolished. There should be a very precise pleadings. And the most important change is, what I want is, the strength of judges should be increased, because this strength is very minimal for this a big country. It's a big country, and the population of the country is around 135 crore, and only 32 judges are dealing the entire country.
Sir, I have a related question to this. Like, what are we talking? So, sir, recently in news I have read that nowadays appointment of judges are made on ad hoc basis, on the contractual basis. Would you like to give any remark that we as a law student aspiring for judiciary don't have the expected number of seats, and now we are on that level that we are appointing judges on ad hoc basis?
Why ad hoc basis? Why not the permanent basis? There are thousands of lawyers. Those are competent lawyers. So why you are choosing the ad hoc and contractual basis? This is the institution where everyone seeking justice. A judge ought to be a man of integrity, man of credibility. He should not be a contractual person. If for assignment basis, you are. We have seen in arbitration also. Arbitrator is a person who is assigned an arbitration proceedings on contract basis. It is not a good thing for the judiciary.
So I went to Saket Court for internship as well, and there the lawyers from the government side were also from the contractual basis. So it seems very shocking for me that our very renowned profession is going on contractual.
Lawyers may be on contract basis because lawyers are not delivering the justice. They are only assisting the courts. And contract basis, if lawyers are engaged on contract basis, it means they are working for a client. Every client paying him, it is on the basis of the contract. It may be any arrangement with the client and lawyer. But for judges, it is not a good sign. It is not required for the judiciary.
So my next question is related to the students class. That is your firm is absorbing some of the interns at the moment, or anything like that, and also if any interns want to approach.
Interns are always and they don't need to send me any CV or biodata, because I know they are a student. Only it is enough that they are a student of law. Any intern can contact me on my phone, on my WhatsApp, on my email. They are always welcome.
Sir, so which field what do you, what is your take that on which field the students will get the maximum exposure if they intern with your firm? Which field of
I'm not getting you properly. What?
My question is, in which field of law the students or interns will get the maximum exposure if they intern with?
For new lawyers or for new advocates, I only advise that there should be an habit of regular reading of law journals, regular reading of leading cases. So automatically they will get their own way. It is not the any set idea or any set of what would I say route. What should they do? There is no shortcut for this. They have to learn a lot, and the learning is the best process to become a good lawyer.
You would like to give any advice for the law students and also people who are looking to go in the arbitration field especially?
There is no difference between arbitration and litigation. Both are the same. It is also the part of the litigation. Basically, the purpose of the arbitration is to avoid the litigation. But practically, arbitration increases more litigation. First, you will go for appointment of the arbitrator. Then you have appointed an arbitrator. Then you go the arbitration proceeding. After that, you will go for the setting aside the arbitration award. After setting aside the arbitration award, you will go for appeal. So there is a lengthy proceeding. Instead, I don't recommend any arbitration because arbitration and litigation both are the same. The purpose of legislation was to avoid the litigation, but it is increasing the litigation. And moreover, arbitration is more costly than litigation. Arbitrator itself charging fees, lawyers is also charging fees. When you are going for setting aside, then you are again engaging another lawyer. So is more it's a part of the litigation. Any other question?
Sir, yes, sir. Sir, I think with that we can end the session. And with the last question, I hope I hope that this conversation will bring a little motivation to our coming lawyers as well as the people who are practicing. I This was very lovely speaking with you, and I hope that it was same from other side. Thank you so much for your time, and have a good day ahead.
Thank you.